Hello, everyone. We've got enough people online now that we feel that we can start and we're not doing it prematurely. My name's Louise Glanville and I'm the current chair of National Legal Aid, and I'm also my day job the CEO of Victoria Legal Aid. And it's fantastic to see you all here, particularly those of you who are joining us online. So thank you so much. I'd like to start by acknowledging the traditional owners of the lands on which we're meeting here today, but also all around Australia for this presentation. Here we're on the lands of the Gadigal people of the Eora Nation, and I pay my respects to elders past, present and emerging, and I note that their lands have never been ceded. I also note the work, very important work that's happening in terms of the Uluru Statement of the Heart, of voice, of treaty, of transformation, and of course the upcoming referendum at some point that we will all be asked to turn our mind to and to think about the future of Australia in that context. So I give that acknowledgement. I also want to acknowledge all of you for attending. Here today we have, apart from the directors of all the legal aid commissions around the country, most of them are sitting on the back little deck over there, but a few in the front rows as well. We've got a lot of staff online from all the commissions around the country, members of the Law Council of Australia and also state law societies, really important in terms of our partnerships in the sector in which we work. I'm very pleased to have with us senior officials from the Attorney General's Department, and I welcome both you, Tanzim and you, Lace, to this event. Thank you for making the effort to be here, and also those from state and territory counterparts around the country, colleagues from community legal centres. I know there's certainly a few listening from Victoria, so welcome to you. With Aboriginal and Torres Strait Islanders Services and Family Violence Prevention Legal Services and Health Justice Victoria, we all form a very important part of the legal assistance sector and the sector more broadly that's committed to this work. There are also, I think, colleagues joining us from the Victoria Law Foundation, I think, as well as New South Wales Law and Justice Foundation, and Legal Aid Services in Canada. So I hope you're online, and I think perhaps you are, and it's wonderful to have this international interest in this most important work that National Legal Aid has commissioned, and we'll hear from PwC in terms of the report a little bit later on. I think that this is an important event because for some time now, both in Australia and elsewhere, we have seen that legal assistance services generally are not something that's often greatly favoured in terms of being funded by governments more broadly. We have benefited in lots of different ways from governments at both state and federal levels, but I think what this report tells us is something about the core nature of legal assistance services and the way in which the services that we all provide, no matter who we work for within the legal assistance sector, really do assist a whole range of other public and community sectors in which we find the users of our services engaged, whether that be health or housing or transport, whether it be immigration, the NDIS, whatever it might be, a really important piece to see that intersection with other justice systems and the difference it makes, particularly from Victoria's perspective. I think about the child protection system, for example, and what that sort of early intervention legal assistance means for people's passage, not only through that system, but perhaps avoiding their passage through criminal law and other justice systems. I think it's also a really significant thing to say that we often work in the legal assistance sector with those who are the most disadvantaged. And we often reflect in National Legal Aid about the fact that many people who we assist, for the very many people that we assist, and that's hundreds of thousands in any given year, there are as many, if not more, who we don't assist, who also sit below the poverty line in Australia. And I think this situation has got worse over the last decade, in my view, and we'd like to think that we can work with both state and territory and the federal government in particular in thinking about what it means to truly have access to justice for all Australians who need it. I think the importance of the legal assistance sector is that it can make a very positive impact on people's lives. And I've told this story already twice today, but I'm going to tell it again. As I was coming into the meeting this morning, so I've come up from Melbourne and I'm staying over just on the other side of the railway line. And so I was crossing to get to Castlereagh Street, and I came across a woman who was, and it was pouring with rain. This is at 8:30 this morning. And she stops me and she says, "Oh, are you from around here?" I say, "No, I'm actually from Melbourne." And I said, "What are you looking for?" And she said, "I want to go to Castlereagh Street." And I said, "Oh, that's where I'm going. I'm going to Castlereagh Street for a meeting." And she indicated to me that she was really keen to see a lawyer there at New South Wales Legal Aid. And I said, "Well, actually, that's where I'm going, to the Legal Aid Commission there." And she said to me, I said, "Oh, you've got a particular issue?" And she said, "No." She said, "I want to thank the lawyer that's done all the work that relates to my child being able to become a participant in the NDIS." And she was coming not for any other reason, but she had a little present for this person. She wanted to thank them for the work. And her words will sit with me for a long time, and it made me quite emotional. She said, "I can't tell you what a difference this has made to the life of all my family, not just our wee girl, but also our other children and the parents in that matter." So it is a really salient moment when someone out of the blue tells you what difference it's made for her child and for her life generally to have this sort of assistance. So it's an important story and a good one to remember. But most importantly for me, the work that PwC has done for us really does assist with helping to build the legal assistance puzzle, helping to tell us about what this actually looks like, what's our evidence, how do we understand that evidence, and how do we advocate more collectively? Yes, we've all perhaps got different needs in the legal assistance sector, but more collectively across Australia to have the systems in which we work, particularly the legal assistance sector, recognised for the contribution it makes in a very ordinary way to the everyday lives of people that we know. So I'm not going to speak much about National Legal Aid other than it's the coming together of the all the state and territory legal aid commissions across the country. We are very keen to become louder in terms of our advocacy in many ways in Australia, and to across all our differences across those legal aid commissions, to look for our commonalities as distinct from our differences and really highlight what we think is in the best interest not only of the Australian people but of Australia as a civil society more generally in terms of legal assistance and support. And we're keen, we have a strategic plan that focuses on core issues such as core funding for the legal assistance sector, not just for our own, of course, but more generally, influencing family law policy and funding in this country, but also addressing Aboriginal and Torres Strait Islander justice and thinking about the needs of First Nations people as they would tell us what those needs are, and to working well to promote those priorities with the Australian government with a view to them understanding better the evidence base from which we say the goals that we aspire to are goals that politicians across this country should aspire to as well. So this is a critical first piece for us in terms of broader advocacy on the importance of investing in legal assistance, and I am grateful that you're here and willing to listen to the journey we've been on. But before that, and unfortunately, the Attorney General has had to be in Parliament today, so Mark Dreyfus was unable to be in attendance, but he has made a message for us, and we're now going to play that to you in his stead. And I would start by saying that his support for this report was something that he expressed at the Whitlam Institute, which is a spotlight on legal aid event, which Anne-Marie Lumsden attended on behalf of National Legal Aid, and here's his address to us as part of that. Thank you.
Good afternoon, everyone. I'd like to start by acknowledging the traditional custodians of the land on which you're meeting today, the Gadigal people of the Eora Nation. I pay my respects to their elders past and present, and also to other Aboriginal and Torres Strait Islander people attending today. And I reiterate the government's commitment to implementing the Uluru Statement from the Heart in full, beginning with a referendum to enshrine an Aboriginal and Torres Strait Islander voice in the Australian Constitution during this term of Parliament. I'd like to thank Louise Glanville and the Legal Aid Commission directors for their invitation to speak at this launch. Unfortunately, Parliament is sitting, and that means I can't join you in person. I'd also like to acknowledge the many distinguished members of the legal profession attending the launch in person and remotely today. I thank you for the important work you do in your respective communities. The findings of the benefits of providing access to justice report come as no surprise to anyone at this launch. That legal aid doesn't just help people in the courtroom, but contributes in so many ways to making a better, fairer and more productive society. From the establishment of the Australian Legal Aid Office under the Whitlam government to the extensive legal assistance framework that is in operation today, the sector has always played a critical role in preserving and maintaining the rule of law and ensuring that all Australians have meaningful access to justice. As Attorney-General, my priority, and indeed my responsibility, is to rebuild and strengthen the legal assistance sector because of its inherent value, not only to the justice system, but to broader society. There's no question that legal aid is crucial to maintaining and improving social well-being and cohesion. From providing independent children's lawyers in complex family law disputes to law reform contributions in highly nuanced areas of law such as social security and migration, legal aid commissions support vulnerable and disadvantaged Australians to access the justice system and improve the quality of their lives. Legal assistance is a key principle of the rule of law. This, in turn, is a core tenet of a healthy democracy. Legal assistance services ensure that equality before the law is more than an aspiration. That's why this benefits of providing access to justice report is so important, because it spells out just how valuable legal assistance is to our community. This report highlights that legal assistance services make our justice system more efficient and effective, thereby enhancing the rule of law and delivering a range of benefits that contribute to a just and equitable society. The report also notes that, and I quote, "the pain and suffering caused by unresolved legal issues can have lasting intergenerational impacts," unquote. The failure to resolve legal issues can entrench disadvantage and expose children to violence, reduce their educational opportunities, and result in homelessness and other disruptions. Perhaps most pointedly, the analysis conducted in this report shows that every $1 spent on legal aid services delivers a net benefit to the community of $2.25. These benefits are delivered by way of efficiency savings to the court and justice system, health and welfare savings to individuals subjected to family violence, and savings to the government relating to out-of-home care and family violence proceedings. This report shows what we all know to be true. Legal assistance services have an essential role in promoting safety, security, and ultimately equality for all Australians. It demonstrates that equality before the law translates into equality of opportunity more broadly. Beyond the obvious financial and social benefits provided by legal aid commissions are the innovative solutions and best practice approaches to service delivery. One of the largest areas of the work taken on by legal assistance providers, especially legal aid commissions, is family law. In many cases, the risk of domestic and family violence in these matters is high. The creation of innovative tools such as Amica, the development and implementation of critical programs such as the Family Advocacy and Support Services, and the successful Family Violence and Cross-Examination of Parties scheme are all examples of the way legal aid commissions contribute to the modernisation and efficiency of the justice system. As the backbone of the legal assistance sector, legal aid commissions have always been key partners of government in achieving access to justice. We share the objective of ensuring that every Australian who needs legal assistance will have that need met in a way that is timely and safe. The report we're launching today finds clear evidence that legal aid services provide a net benefit to government. The savings achieved through protecting clients from ongoing family violence, minimising the need for out-of-home care and reducing the need for mental health support and services enable government to invest more in other services that benefit all Australians. The Albanese government is committed to ensuring that Australia's legal assistance sector is robust and fit for purpose. Through the 2022-23 budget, the Australian government is investing approximately $150 million over 4 years in measures impacting the legal assistance sector. As most of you are aware, the current National Legal Assistance Partnership expires on 30 June 2025, and an independent review of the agreement is commencing this year. This will be a comprehensive review that will look at all aspects of the legal assistance sector, including the extent of unmet legal need. It will be an opportunity to show what changes are needed to the legal assistance framework to ensure that current and future legal needs are adequately met. The expertise of the sector, including the report we are launching today, will inform decisions we make about future legal assistance funding arrangements. It's important that the sector's views, your views, continue to be heard throughout the review process. I would urge all of you to participate in this review to ensure the experience and value of your work and the needs of those you serve are reflected in the next agreement. In closing, I want to thank you again for inviting me to the launch of the Benefits of Providing Access to Justice report. I thank National Legal Aid for commissioning this important research. It's important to me that we continue to recognise the significant and far-reaching contributions of the legal assistance sector, and I'm pleased that the report gives an insight into the outcomes being achieved across the country. I will leave you with the words of former High Court Chief Justice Robert French in the final report of the Law Council of Australia's 2018 Justice Project, and I quote, "Equal justice requires equality in access to justice, in access to information about the legal system and advice, support and, where necessary, representation. It is my view that the legal assistance sector continues to play a vital role in achieving that goal of equality in access to justice." End quote. Thank you very much.
Support for the role of legal assistance in this country, and we would also encourage him to use this report in his advocacy with Treasury, with Cabinet, with his colleagues, with the Prime Minister in relation to what we would hope would be a more enduring and lasting contribution to legal assistance in this country. But I must say it certainly is great to see a real Attorney General up there talking about the rule of law and even quoting a judge. I love that. So really good. Thank you for that. I'd now like to invite Mary Whitehead to come up here. Mary is from New South Wales Legal Aid, and Mary's going to talk a little bit about the report just for a few minutes.
Back in 2009, and some of us in the room can remember this project, National Legal Aid commissioned PwC to develop a first-of-its-kind report which estimated the benefits from legal aid services. That report looked at the economic benefits which result from the increased efficiency of the justice system. 10 years later, in 2019, the World Bank undertook a literature review of the key findings from various cost-benefit analyses of access to justice and legal assistance globally, and cited the PwC report as evidence of best practice ways to analyse and capture the economic benefits. Last year, in 2022, National Legal Aid commissioned PwC to undertake an updated analysis of the benefits of providing access to justice, with a focus on federally funded legal aid services in family and civil law as part of its goal to increase core legal aid funding. We're pleased to say that this analysis has now been finalised, and its findings are crucial in providing a better understanding of the significant contribution legal aid services make, not simply within the justice system, but also in terms of contributions to better outcomes for people experiencing disadvantage and the broader community. I'll now hand back to Louise. Okay, all right. Well, then I'll introduce Jeremy Thorpe, who's the partner of integrated infrastructure from PwC. He was the partner who led the PwC work on our report, and he's going to provide an overview of the report, tell us what a cost benefit analysis is and isn't, and give us an outline of the report's methodology and the findings. So I'll hand over to Jeremy, and thank you very much for coming along.
Good afternoon, everyone. I feel like you've heard the punchline. So it's like you've read the conclusion to the book, and now I'm going to fill you in on all the middle gumph that you would normally skip over. But as an economist, I'm going to tell you the interesting stuff now. So let me just. There's a bit of history, and there's a little bit of history in all of this today. I was actually the partner on the job in 2009, and the manager on that job is now the chair of the Productivity Commission. So just showing you that people go far higher places when they leave PwC. But can we go to the next slide, please? So there is a bit of history here, and I think that history is kind of important. But it's also important to understand what we have actually analysed today. We've really just focused on Commonwealth funding and Commonwealth family law as the issue here. Now, some will say, gee, that's very narrow, but if you look at the chart on the screen, you can see that 96% of legal aid cases by law type were family law, only 4% were civil. So we're focused on the vast majority of what legal aid or legal assistance organisations actually do. And if you can see $267 million Commonwealth funding for legal aid, it sounds like a big number, but as you'll all be very appreciative, it's spread over the organisations across Australia. And the other little chart that you see on the right-hand side shows you how funding has changed over time. You add those numbers up in each year, and you obviously don't get to 100 because there are other funding sources as well. But what we've seen over time is that shift, that state funding has become far more important, or maybe we'll put it around the other way. Commonwealth funding has become relatively far less important over time, but yet the actions that legal aid assistance organisations are doing really relates to Commonwealth matters. So we're seeing, to some degree, states cross-subsidising the Commonwealth in this space, and so that's an interesting kind of basis for having a discussion or renegotiation about future funding arrangements. We drew on a literature review for this process. As was mentioned, there's been a lot of international interest around how you think about cost-benefit analysis and legal aid organisations. We actually, though, are very thankful to Mary as rounding up the various states and territory bodies, and we couldn't have done this exercise without the help of the various organisations. It does show you the challenge of a system where every state and territory doing their own thing slightly, and so the superpower that economists had to be brought into space here, and that is making assumptions. So sometimes it's there's a lot of information in a particular area. Sometimes we would have material from one or two jurisdictions. So there's a degree to which we've had to kind of fill the gaps in to paint a national picture. Next slide, please. And I won't go into tons more detail, but yes, we did this in 2009. It's not often that you have another bite of the cherry, so to speak. And so the Productivity Commission, in its access to measuring the benefits of in the Productivity Commission's work in 2014, was interesting because it critiqued our 2009 work. Then the World Bank also critiqued our 2009 work. But coming back now in 2022-23, what we've been able to do, and I'll show you how and why, is actually extend the analysis and address many of the criticisms that the Productivity Commission had. So it's actually an evolution. We haven't just taken whatever happened in 2009, updated some numbers in an Excel model and spat out a result. This is a start from the beginning, and it's very much trying to say, look, the Productivity Commission was right. We didn't have the data in 2009. So let's go find the data and let's tell the story. And I'll explain what that story looks like in a minute. Maybe the threshold question is, what is a cost-benefit analysis? That sounds kind of scary. It's about numbers. The trouble is, when you say it's about numbers, most people think of a financial analysis. So an accountant would do a financial analysis, and you add up all the things that you spend money on, and all the things that you receive money from, and that you add the two together and you get a number. But government isn't a financial exercise. We do things and government does things, not because there's a financial return, but because it creates value for the community in some way or other. So the job of an economist, and this is where people often don't quite get economists, they're actually very tender at heart. It's not about markets. It's about trying to value the things that aren't markets, where there is not something bought and sold, but nevertheless, there's a benefit or an impact on a community group, and trying to put a value onto that, which you can't see in a market, but nevertheless, it is real. And I think the Attorney General kind of said, well, duh, of course there's going to be benefits here. We know there's benefits, but the challenge is actually trying to put credible estimates around that. And obviously, when you're talking about justice, those benefits are quite wide-ranging and depends on the nature of the action, the nature of the issues that the person is experiencing. At the end of the day, the economist is looking for what's called a benefit-cost ratio of greater than 1. In other words, it costs us $1, we want to be generating more than $1, and it doesn't make sense to do something if you're not generating more than $1. But equally, we know, and you'll see in a moment, that we can't value everything. So there's some things that we can't credibly find an estimate for or credibly make an assumption about. And so that you need to think that number then, that $2.25, and you heard the punchline before the story, is really quite a conservative number. Now, how conservative? I think you as practitioners will actually probably have a better sense on the things that we haven't valued, whether you think they are really significant, change this number drastically, or they're things, but nevertheless, we're still in the ballpark. And I've probably gone ahead 2 slides, so I've just talked rather than anything else. So that's I think that's summing up just what I've said. So let's go on to the next one. This next chart, and the colours don't scream out at you, but the green coloured boxes are boxes that we've put an estimate of a dollar estimate on. The non-green, I don't know what you call that, slightly murky boxes, we haven't put an estimate on. So they're in a sense our extra value that we haven't yet got a handle on. But just showing you how far we've come since 2009, it's only those first 3 boxes on the left-hand side that we valued in 2009. So the methodology has improved, and we've taken got a broader conception of how National Legal Aid is helping different groups across society. And we have grouped things into 3 groups. One is the efficiency of the justice system. In other words, there's savings if we can make a more efficient justice system. The 3 key things that as I said, we valued in 2009 was avoided costs of, as a result of having legal representation compared to someone who wouldn't have otherwise had legal representation. And this is what we're trying to do here, is we're trying to compare it to what would happen if National Legal Aid or the various legal aid bodies didn't exist. So we're trying to think of an alternative scenario of what the world would look like with more people effectively being self-represented in that environment. The second one was, we believe that National Legal Aid really encourages some people to go to mediation when they would not have otherwise done that, leading to either a more tailored result or a quicker result, and that has a benefit. So we think that's important. And also the efficiency of the duty lawyers, which was actually called out by the Productivity Commission's critique, that duty lawyers actually can help those who still are going to be self-represented. And so that, in a sense, they don't clog the system up. The duty lawyers can effectively acknowledge that they're self-representing, but do that in a more effective manner. But we don't do legal aid so that the legal system works better. That's kind of not the purpose, but nevertheless, it's an important purpose. But the value to individuals from an access to justice issue probably is the thing that motivates most people. And as you can see here, we've quantified the top 2 boxes. Improved livelihood and well-being from reduced domestic family violence, and reduced pain and suffering from efficient court proceedings. Justice delayed is justice denied is kind of one phrase, and I'm probably using it incorrectly, but justice delayed has a cost on people. And so that's the second box in that process. But when we're talking about family law, as you saw in those first charts, the family law is such a significant component. The livelihood and well-being from reduced domestic violence is something that affects both the direct party, but also the families associated. And I love the story about the NDI, child in the NDIA. It's a lot of this is not just about the individual; it's about the community around that individual. Again, I won't talk too much at the moment about the alternatives. But wider government benefits also accrue. Reduced domestic violence actually has a cost saving for government for support services. Equally, reduced out-of-home care, where children are not dragged into that process, has a wider benefit to government. Again, we don't do legal aid to benefit government, but they're important because we need to understand the breadth of the stakeholders involved. Thank you. So what we really did here was looked at what we called legal pathways. And what I mean by that is we compared the status quo, in other words, that national legal aid exists, and considered what pathways people would have under different areas of law, under Commonwealth law matters, if legal aid support wasn't there. So we looked at the data from national legal aid for various actions, and we looked at, and I'll show you what a pathway looks like. And really, the ultimate view was for many litigants in that environment, there'd be inferior legal outcomes who would have to use alternative legal pathways. And we put $1 on that. And what I'm going to do now is show you when I talk about pathways, what does that look like? Just here's an example. If you can see litigants that currently use legal aid, we've got a number on the far left-hand side. What we've suggested that if you didn't have legal aid, you would self-represent. 72% would have an interim order and they would come out of the system. And it's a relatively low cost without legal aid, but it's there. But for the other 28%, how do they get allocated? What pathways might they go through in the process? And you can see different pathways have different costs associated with it. And so we've done this to map out the various range of options. Again, the key here is what are the volumes of people? What areas of law are they in? What are the costs? And what are the likelihood that an individual pathway would be chosen? It looks relatively simple when you do it that way, but when it's a whole lot of data that builds up behind that. And very much thank you to Mary and the team in National Legal Aid for helping us test some of those assumptions, test some of those values, particularly around the likelihoods. So when you do that for everything, you add it all up. The next slide is going to show you. Next one again. When you add it up, what we find is $601 million of benefits generated by National Legal Aid. But what we see is, if you can see, category B, avoided cost to individuals. So just over half of the total benefits accrue to individuals. That kind of makes sense. And in fact, on these numbers, that is a positive benefit cost ratio in and of itself. So even if you weren't thinking about the benefits to government, you weren't thinking about the benefits to something else. Oh, timing, it's always it's fantastic. If you weren't thinking about anything else, it still makes sense. And again, I've said we haven't valued some of we haven't been able to put a value on some of the benefits, but nevertheless, avoided cost to individuals just makes sense. But nevertheless, also, the system is more efficient by $176 million in a year, and government also benefits by avoiding support in various forms of about $93 million. So a benefit cost ratio 2.25, as the Attorney General said, well, of course. And I think this is trying to put the language of course into a dollar number that you can then go and have a discussion with Treasury and Finance. And I think we've got one more slide. But as I said, and I don't want to forget the qualitative benefits, because you often you do numbers and you focus on the numbers, but they're the things that we haven't put a value on. I think we don't want to lose sight of that in this process as well. So again, I think the key is really around we don't have a sense of the relative quantum here, whether one is particularly larger than the other. But for some individuals or for some people in the justice system, the non-quantified things may actually be significant. So please don't lose that in your narrative when you go and talk to people. And so that's where I'm going to leave you today. But I'm very happy to take questions, and thank you very much to Legal Aid for sponsoring this process.
So thank you very much for that, Jeremy. It was really good to hear that analysis of not only the method, but just how to understand it and how to describe it, because you want to be in good nick when you're talking to decision makers about what this really means and what it looks like. I think the other point I really took from it is a lot of the savings are significantly driven by avoided costs in family violence. And if I look at that, I think it's about half, Catherine was telling me, about half of that 600 million figure, 378, does relate to avoided costs to individuals and government as a consequence of family violence. So that's a really important piece, I think, to remember as well. So we'd like to open it up to any questions you might have. And because we're well organised here, I've got some questions just in case no one else has got any. But would anybody like to ask some questions or a question of Jeremy in relation to this work? In the front row, there would be John Borsick. John, thank you.
With this type of work, are you able to extrapolate other areas of service like courts, or can you do things like identify the third unit value of a service?
I'm an economist and I'm a consultant, so the answer is always yes. Of course we can. But the tools are the same set of tools. Obviously, well, I don't think you can extrapolate these numbers per se, because I think you're asking a slightly different question. But it's the tools are certainly the tools to analyse the court system and the court processes. Obviously, you're going to have a different mix. Courts are going to have a broader mix of types of litigation. I'm starting a PhD in about litigation, so I know the categories. There's quite a few. So we've focused on really effectively one category here, family law. Obviously, you're going to be looking at another 15 or so if you look at, say, the federal court processes.
Thanks, John. Other questions, comments? While people are thinking, I'm going to ask, what else could the legal assistance sector do to build evidence in this space? Cost benefits.
Yeah, the real challenge is, I think, also about culture and how it changes long-term behaviours. I think we are very much focusing on what happens in a particular year. We don't know, when we're not trying to estimate at the moment, in a sense, what the lifetime of benefits actually occur. Particularly when you look at the out-of-home care discussion, it's a this year number, but keeping a child out of the system, out of a certain system, may actually have lifetime benefits that maybe we're not capturing in a particular way, and that's a hard thing to put a particular value on. Preventative work, I think, is the key other challenge that's hard to put things on, and we've mentioned some of those up there. Things that don't even get to litigation. You're just trying to. There's an answer that is, this does not need to be litigated, but explaining to someone that it's in their and everyone else's interest, and so we don't necessarily capture all the full value of that important, in a sense, preventative action. But you are not alone. The health system has that exact same trouble. We talk about measuring the impact of in the health system, avoiding disease and so forth, but we struggle with that preventative discussion. So government knows that prevention is the most effective form of savings in many cases, and not all, but in many cases, and but it struggles to put something on it because it's harder to point to a success of something didn't happen.
I think the environmental world and disaster work is a really good example. We've learned a lot about that across national legal aid, particularly simple things like people checking their insurances before the fire season or before the flood, you know. Yep. Yeah, just really being on top of these things and thinking about how that works. So there's so many parts to that. I think you've got some questions online. Yes.
Yep, the first one is from Louisa Gibbs from the Federation of CLCs in Victoria.
Hello, Louisa.
Her comment is, hi, thanks for this great research and she wants to know how the services provided by community legal services factored into these findings. That is, if someone was not helped by a legal aid commission but was supported by a community legal service.
That's a really good question, and I think that comes into the category of what further work could we do. Did you want to comment on that just generally? Because I would see that, Louisa, as this was definitely about legal aid commissions and the work that we do, but your point about people moving through different parts of the legal assistance sector and what are the relationships there and what are the cost savings there, and community legal centres are very important to us gaps in terms of the legal assistance sector would be another component of work that could be done. But any reflections from you on that, Jeremy?
I think you probably nailed it. But again, this is all about pathways. And so we were looking at pathways that legal aid is focused on, but legal aid itself sits in a broader justice system, and there are other pathways in that. And the report explicitly acknowledges other groups like community legal centres, but that's not part of exactly what we're doing today. But as you said, maybe in 13 years' time, that's the evolution.
Thank you for that. I mean, at the risk of putting 2 more questions online, yes.
Okay, the next one is from Mark Woods, the Law Council.
Hello, Mark.
Can you say whether the savings to government are to state or federal, or is it both?
Thank you.
I don't think we made a strong distinction, but most of this is federal. Federal laws will be in the family law court, so it's probably captured in the federal spending, but it's not something that we've made a hard judgment call about.
And your next question?
The last question so far. This is from an anonymous attendee. With the quantification method applied to achieve the family violence figure of 330+ million, how much consideration was given to what proportion of the 22K would have already been spent on average at the time a high-risk family violence client has engaged with the family law system?
This is the early intervention piece, really.
Yes. Yeah, off the top of my head, I don't have a specific answer, and my answer will be, please have a look at the report. And I suspect you'll find references that underpin most of the assumptions, and I think the family law one will certainly be there. Yes, these are averages, and so some people are going to save more, some are going to save less, and they may have spent it on, again, pathways out or supports outside the system. When we take pathways, in some senses, you've got to take a judgment as to black and white divergence, rather than I trundled down one pathway and then eventually I decided that I will take another. So again, this is the economist making some assumptions that sit behind that, but I'm confident that the aggregate is probably right, but at the margins there'll be slightly different answers. And
2 more questions. There's one down the back. So Tessa, did you want to ask your question? Can you come up to you might have to come up here so you can. Yes, do you need to? I'm a bit confused with that.
You're going to share.
Excellent. Oh, now we can share. There you go. Tessa.
Let's take that.
Yeah, you can have it.
Thanks very much. This is really important and timely research. Tessa Boyd-Kane from Health Justice Australia. Do you have a sense of how the benefit to cost ratio compares to other services? I'm not thinking within the legal assistance sector, but within health and community sectors more broadly.
Thanks, Tessa.
We haven't done that, and for a whole lot of reasons, and we haven't compared it to building a nuclear submarine or building a stadium or the myriad of things that government does, because in a sense you need to make sure that they're done on a consistent basis, and what often happens is you don't see that. And so no, the short answer is no, we haven't. But maybe I'll just give you if you're reading things with benefit cost ratios of enormous benefit cost ratios, default rule is just don't believe it. And I think we've tried to be relatively conservative, and we haven't quantified what we haven't felt comfortable quantifying. But that type of number, if you put that in I'm ex-Treasury, if you put that in front of a Treasury official, to me, that's a credible number that says that's something worth doing. So don't look for 10s or 20s as a benefit cost ratio.
Thank you for that. And you've got a couple more online.
Yes, a couple more. The next one is from Eleanor Roseman from Women's Legal Centre in the ACT, and also Women's Legal Services Australia. She's wondering if in your consideration of alternate pathways, you also consider people who would abandon their matter and the costs of this, particularly to government systems.
That might be one that we miss in some senses, that someone should have actually, often this is about being caught in a process they didn't want to be in the process. And there are some that, yes, maybe just totally discouraged, and I don't think we probably have captured that. That's the scourge of actually trying to rely on data we don't have a good sense of what those who have just felt. It's not so much making a judgment that it's on the merits they're not successful, but just get frustrated or the system isn't supportive of that process. So I feel we're being exposed by the people who know the detail on the day to day. But again, as I said, I think we're trying to find the core value in this process.
And just on that, I'd say these are all great questions for the more collaborative work that the legal assistance sector could do on other areas where cost benefit analyses assist government to understand what a modest spend in legal assistance means for the punters and other systems overall. So I think that's great. Two more, and then might have to call it a day.
Yep. So the next question is from Jonathan Parry from Northern Territory Legal Aid. And his question is, was any consideration given to the difference in savings and costs, etc., based on jurisdiction?
Short answer, no. And for a couple of reasons. I suspect the league table probably wouldn't be loved by many people in the room, depending on where they are on the league table. And so we weren't trying to peg one jurisdiction against another. We have tried to do this on the totality of the system. And obviously different states have different mix of work. They have different engagement at various stages. They offer a different range of services. So we've tried to do this in its totality. As soon as you start to compare individual states or territories, you need to really have a story that's on a comparable basis. Otherwise, there'll be more questions would go to we're different. And that's not the message we're trying to have here. We're trying to have the story of there's value in the system. How you want to organise it internally within the system, that's another project on another day, I suspect.
And the last question, I think, is a really good one to end on. It's from Elizabeth. This research is very powerful, but it seems like a lot of sectors are developing powerful evidence about how much funding them saves government. Can we identify what makes this particularly compelling or different?
Very good.
Look, I think at the end of the day, this is one that it hits the three stakeholder groups. It makes government more efficient. It saves government money, and it produces better, just outcomes that support individuals. It's not many things in society. Maybe health is the only other area really that you're looking at that kind of hit those three things and appeal to government in three different narratives that all add up to something. I think the other one is, as I said before, this stacks up. It's greater than one just if you are looking at the individuals. So you're not relying on those other sectors to kind of drag you over the line. They're all just cream on the cake. And so I think the message becomes more powerful when, again, you can talk to different audiences, but knowing that the numbers actually just make sense.
Thank you so much. And for all those terrific questions that people have asked, really instructive. So Jeremy, can I thank you and PwC for your work? It's been terrific to work with you, and we look forward to further work into the future. Thank you so much. Yes, please clap. And just in closing, I'd like to thank Monique Hitter, who's here, but I had to do something else at the beginning of this. So Monique, thank you to you and to you, Mary, for New South Wales sponsorship of this work on behalf of National Legal Aid. National Legal Aid, we share things around, and we all have slightly different interests as well, which is hugely handy. And so we each pick up big and different projects across the country. But it's been terrific the way in which New South Wales Legal Aid Commissioners manage this work, and the way that you in particular on a day-to-day basis with Monique have led that, Mary. So thank you so much. I think I also want to acknowledge, and I know a lot of these people will be online, those in the working groups of National Legal Aid who have found the data and contributed the data to what we need. It is no easy work, this, and it takes lots of debate and consideration to decide what finally goes in there. So thank you for all your input into that. And I also want to thank Catherine too for your work in organising this and getting us to this more public statement. Catherine's done some media this morning on the ABC, so hope you've had a bit of a listen to that. And we really want to get the messages out to assist the Attorney General. He's given us the theory. We want to give him the practice to talk to his colleagues well and thoroughly. And I know he has some of his more senior staff here who can go back and report on this in good form. But I'd like you to take away the following messages, which we've distilled and we think are the most important, apart from the actual figure, which you can hang on to, 1 to 2.25. We think that welcoming this additional evidence around the benefits and outcomes for the individuals, the community and government in investing in legal assistance is another important contribution to this whole overall area of cost benefit and the legal assistance sector. We do note the rigorous methodology that's been used and the way in which the criteria that have been used are, it's actually cautious about the claims. So I feel good about that because I feel like it can only perhaps be better than what we've said, but this is a really important statement, I think, for us to be able to make. I think this is one piece of evidence that supports the value of the legal assistance sector, but many of our colleagues here and online in the legal assistance sector have other pieces of evidence that can contribute to this as well. And most importantly, I think we've all been on the journey of our individual users of services and clients telling their stories to us about what makes a difference from their point of view for the legal assistance sector, and that lived experience, that direct evidence, that use of people's stories with proper consent about what difference it's made for them are really potent and powerful for us to be sharing with government. And this adds to that as well. And we want this evidence really to be used by all of us in the legal assistance sector to really advocate for what, after all, are our most common interests in the space that we find ourselves in. So I wish you all well, and I look forward to continuing to work with you all in terms of our advocacy for investment in legal assistance for what is people who are experiencing usually quite extreme disadvantage. So thanks for attending. There's food over the back there for those of you who aren't online. So please help yourself to that, and thank you very much. Thank you.